You're shaking your head. No, you were.
They were blocking the door so I couldn't leave.
You should never have
I know,
been there.
I understand that, Your
Not
Honor.
ever, never have stepped foot on there.
I know, I
But
get
that was your 20th time. All right. We will go on the record in the matters 24 TR 112, 25 CM 30, 25 CM 125, County of Burnett, State of Wisconsin versus Victoria Mott. The state appears through District Attorney Kevin Schmidt in person. Ms. Mott appears in person with counsel Joel Feliski. We're set today in this matter for the sentencing part of this case. We did have Ms. Mott here on August 14th, in which she pled guilty to violating a harassment injunction times 3 counts. We have 2 victim impact statements to hear today. We will move forward and hear those. However, I did just get a recent filing as of today from Ms. Mott in this case. I wanted to ensure that Mr. Schmidt had an opportunity to review that.
I did.
All right, I did as well. Although it is very difficult, just saying on the record, very difficult to get filings on the day of sentencings, especially when it's multiple pages. It's very hard to find time to read. All right, so Ms. Bauer, we have 2 victim impact statements. One may come at a time and sit at that black desk. You can state your full name for the record or your initials, whatever you prefer. And if you're going to read something, please read it slowly so that my court reporter can take it all down accurately, okay?
Christy Haskins.
Can you please make sure that the microphone comes down to you? Thank you. Okay.
Christy Haskins. Is that better?
Is that even working? Can you hit on the top of the microphone?
That's not working.
Oh, is it working?
No, it's red.
I think red's fine. Just tap on the tap or tap on the top. Yeah, it is working. So just bring it a little bit closer. You didn't get a new one for there apparently. All right. Okay. You may begin. And it's Christy, K-R-I-S-T-Y.
Correct.
Okay. Thank you.
Your Honor, thank you for allowing me to speak today.
And I'm hearing already that it sounds emotional or like it has emotion. And so I'm going to just let you know if you need time to stop, I'd rather you stop, take a breath, take as long as you need to compose yourself, because again, it gets difficult for my court reporter to understand.
I'm requesting that Victoria Mott gets full punishment for all violations she incurred. It's been proven that Victoria cannot accept any implications as she is not seeing the consequences in her actions. She repeatedly violates the restraining order against her, and yet nothing has deterred her from the fear or constant harassment she has put on this family. While we have been on this constant merry-go-round for the last several years with Victoria, we're hopeful that today, sentencing, that Victoria will finally see the hurt she has caused our family, my husband, and myself, along with our entire family, had to deal with her showing up randomly whenever she feels like damaging property, also almost running over my husband on the property, driving over our septic system, doing donuts in our yard, the constant fear of vandalism, physical violence that she had incurred on me. This is all we've endured is not easy to be explainable. Our family should feel safe in our home. It should not feel that our property can be damaged at any time of the day. Your Honor, we ask for peace. We would like to also request an extension on our restraining order for the maximum allowed or per your discretion. We truly hope that Victoria has time to reflect on what she has damaged, what she has done. We have both, me and my husband, have traveled many times back and forth from here to other properties that we had, leaving work, spending several days at the property on numerous occasions because we did not feel that it would be safe if we were not there, even with the security cameras that we put up. The defendant has proven her inability to acknowledge or to stop showing up. She continues to be there, even after, like, right after we were in court. So I urge you to honestly sentence her to maximum penalty. No one should have to do this. No one should have to live like this, not for just my sake, my husband's sake, my grandkids, and even my kids that are underage. We can't enjoy the property or properties around the area because of this. How would you like it if you're laying on your couch sleeping in the middle of the night and she drives around your property recklessly, screaming profanity outside the window? This is not one time. This is several times. She has not stopped. And I don't think she will until you honestly make her pay for what she's done. So I thank you for allowing me to speak.
Thank you, Ms. Haskins. I do have to address one thing. You did ask for an extension of your restraining orders. This is not the proper venue to ask for that. And plus, they are through 2027. So there's plenty of time to look and assess before you were to ask for something like that. But in the criminal case, I cannot go to the civil matter and adjust that. Okay, just letting you know that part.
Thank you.
All right, thank you. Mr. Haskins?
My name is Jason Haskins, and I am Miss Christy Haskins' husband. A lot of the stuff overlaps. Do you want me to go through it all again?
You may. This is your time to let
Okay,
me know what you
okay.
want me to know.
So basically, starting on July 14th, 23, there was traumatic episodes with Miss Mott, and basically on our property, continually telling me how she's an independent woman, she doesn't need help. Very violent, always violent towards my wife more so than I. Going forward, that's not the property on County Road A. We spent the money on an ADT system with 5 cameras. The cameras seemed to always be in the position that didn't catch her, meaning she would go in the bottom door or the back door, slide in a bedroom window, however it may be. And I witnessed this once. I was in the bedroom where she thought my son would be because I had back surgery. So I was laying on his bed and I could hear a knock at the window. And my 16-year-old son had just gotten a newer used vehicle, which she did not recognize. So she's screaming through the window, "Who's in there? Who's in there?" And my son and I both woke up like, what just happened? Went outside. That is when she was driving erratically up and down the driveway at a high rate of speed. Stopped just 2 feet short of hitting me because I was not very bright. I stood right in the driveway with my hands on my hips, like, what are you doing? Didn't even let up till 2 feet and then finally stopped. Eyes were wide open. So whatever that indicates, I don't know, but wide open. So that was that instance. Basically, I agree with my wife. I don't feel safe going up there. She has many friends that have come on our property. Matter of fact, I confronted one of them, which JJ Lehman is the gentleman's name, and asked him why he was there. And he explained he was there for Tori. And I said, I don't want you on my property. I think right now you're trespassing. Let's call Burnett County and get them coming. Well. So we got in the argument, and his girlfriend thankfully convinced him to leave. So we didn't have an altercation, but again, another fine instance of something that I don't know, I own a property and I can't even use my property. My son lives on the property, and whether She shows up whenever, however, it should not happen. We have the restraining order. And I swear to God, it's almost like it's a challenge. She comes there more now. So, and currently now, her stuff's stored at the house, her dog's at the house, and her kids come and stay at the house. Now, I don't understand why. And due to the previous altercation she had with my son, I don't know why you would keep showing up there with all of your stuff. But anyway, that's where we're at with that. I probably, Your Honor, went up there from Hudson, Wisconsin, no less than 2 days a week for almost a year, just to deter this. Didn't stop her. As a matter of fact, she bragged to me that she was at the house when I was sleeping there at the house because I was downstairs. So I don't know what it's going to take, whether it's, jail time, whether it's taking care of the damages she's done, however it may be, it needs to happen. Previously in her life, she's gotten out of pretty much everything with a slap on the hand and just don't do it. And I don't think she's learned anything. So, I don't know if I'm really missing anything here. It basically just comes down to that. And before all this started, I tried to talk to her and help her through things. And then after I'm a strong, independent woman and I don't need help. Okay, well, you're not getting my help. So, and I guess the only thing I would like to say in reference to Tori, and hopefully she's paying attention, is spend more time taking care of your children, having a consistent job, not drinking, not doing other things, and you would be a much better person. And I think that's where we're at with all this. I don't know what else to say or do that would sway you any other way as far as what she could do to get better, to get back on track. So I guess that's it, Your Honor.
Thank you, Mr. Haskins. You can go have a seat. Thank you. All right. Mr. Schmidt, argument and sentencing recommendation, please.
So I'm going to go back a ways because I think there's some important historical context for the court to understand why we are where we are now, as well as to give some context to the letter that Mott wrote to the court earlier, which I imagine was pretty confusing for the court if it didn't know the history.
It's not. For the record, I'm very familiar. This goes way back to, I believe, 2022 with Jordan Haskins and criminal charges. And then there was an injunction. And then quite honestly, I have had cases involving the Haskins in Washburn County. I've had cases involving Ms. Mott and the Haskins in Burnett County. I'm well aware, and I was just going to say, when you're done, I'm taking judicial notice of the 22 CF46 case with Jordan Haskins, as well as the other matters involving Mr. and Mrs. Haskins and Ms. Mott. But please, for the record, argue all that you're intending on arguing. I just wanted everybody to be aware. I have a really good memory and I recall the facts.
Sure. I'm actually starting in 2016.
2016.
2016.
Could go back to there, but I don't recall off the top of my head what happened in 2016.
You won't because there's no case associated with
Okay,
it.
then I wouldn't be aware of that.
No, I'm going to be talking about law enforcement things too you wouldn't be aware of. In 2016 is when Jordan Haskins, with his then significant other, Courtney Strunk at the time, purchased the property we're talking about here. They lived together until in 2021, the property was quitclaimed entirely to Jordan. They eventually split up. 2021 is also the first time we had a domestic case with Miss Mott and Mr. Haskins. It was a domestic DC and battery. Because of his limited history, it resolved as just an ordinance in this court. Another incident happened that was more serious in 2022. Victoria was still residing with Mr. Haskins. Without bothering to go into the facts, because I don't think that's necessary, it eventually resolved with Mr. Haskins entering a plea to a domestic battery and a strangulation. He went on a deferred agreement with the strangulation. He went on probation for the battery. The strangulation DJOC actually ends in like a little under a month. The term of probation already ended because it was probation on one misdemeanor. During the course of the case, as many domestic abuse victims try to do, Victoria Mott tried to recant her statement. Because we had body cam already back then, we pursued it anyways because her statement on the body cam at the time of the incident was so compelling and Mr. Haskins was so incriminating. During the course, they both did the CRA class to start contact before the case even concluded. When he was placed on probation, DOC, regardless of what the court orders for contact or no contact, can always do their own thing, what they think is safe. And when they have a domestic battery probation with a person also under the plea to strangulation, they chose to do just no contact at the start until, hey, lay off the training wheels later. During the course of that probation, Jordan did continue to have contact with Victoria, and he served some jail time for it during the course of that. About a year and a half into that, Jordan transferred the property to his parents on a quitclaim saying no consideration. 2 days later, all three of them, his parents and Jordan, filed for restraining orders. Jordan would abandon his restraining order while Christy and Jason would get their restraining orders. That's the restraining order we're saying is violated here. This restraining order is a little unique in that it doesn't just prohibit contact at residences. It names specific addresses regardless of whether they're your residence or not. And this is one of those addresses. Regardless, Jordan Haskins has continued to have a relationship with Victoria Mott, as evidenced by there have been many other of these reports, these referrals of these violation restraining order that we never charged because they were essentially Jordan admitting that she was there on his behest, or Jordan asking, is there anything I can do to end my parents' restraining order? He's continued to live at the same property continuously, even after he gave it to his parents. He seems to have continuously lived there for almost 10 years now. Part of what I think the victims have alluded to, Mott avoiding camera footage so successfully, that's how. He obviously knows where all the cameras are. He can aid her in avoiding those. Regardless, when we got the first spat of those referrals for that kind of restraining order, they weren't as severe. We actually met my office with Victoria Mott back then in terms of her being the victim of the past domestic abuse case, and explained to her, Christy and Jason Haskins have nothing to do with your domestic abuse case. This restraining order through the full faith and credit clause, if you violate it by going to this property, because it says go to the property, even if you have Jordan's permission, is a violation, and warned her if she continued to do it, we would be filing cases. She continued to do it. We filed these cases. The behavior got more and more specific and targeted towards the victims, Christy and Jason Haskins. There's really no reason for it at all for her to be doing that, especially when she's continued to have this on again, off again relationship with Jordan throughout the whole time. That is why in this case, Victoria Mott has no criminal history. So normally you'd look at this and say 3 convictions and a recommendation for 30 days jail right off the bat with probation. Is that too severe? No. I think you've heard the impact on the victims back there, how much it's distressed them, how much unpredictability it puts into their enjoyment of their property. And I think it's necessary here because of the repetition. I wanted these 3 convictions to show the repetition, to lay the basis for habitual criminality if it happens again in the future. And I wanted these 3 convictions to show how serious it was. I think the 30 days jail is necessary to show, we know with first-time offenders, the most effective types of incarceration sentences are short ones, because you put them in too long, they create bad contacts, they create bad behaviors, they get new bad friends where they can hang out at bad places with. When you have someone who doesn't have that criminal history, the short-term shock jail sentences, studies show, are most effective. So that's why we're doing 30 days jail there. I think that's the best way to deal with that in this case. I think that the conditions of probation should definitely include something looking at AODA. I can't show in any of these that she was under the influence of anything. I know one of the victims has said she had wide eyes and they think that's involved. The only basis I know for it is the domestic cases we had in the past. She had used alcohol for those. In her statement where she tried to recant the second one, she talked about substance abuse issues. I can't think of any other way to explain her behavior in this case, in these cases with targeting these parents of Jordan Haskins. Nothing else makes sense. There has to be something either deeply related to substance abuse or to mental health. Something is going on there to explain why a person who is 31 years old is suddenly behaving in this manner, this consistently over this period of time. You'll notice with the counts that we charge in this complaint, there's actually a significant period of time that these all occurred across. They weren't 1 week, next week, next week. So for those reasons, I think the probation is necessary. I think the jail is necessary. I hope the court has the full context, again, idea of what sort of issues we're dealing at with Victoria Mott, because she shows evidence of substance abuse, of mental health issues. She herself is a victim of domestic violence. We know she's on again, off again, continuing with that person who has been convicted of doing that to her. There are a lot of complicated issues with her, and I'm hopeful the probation is going to be able to help with that, and the jail is going to be helpful with saying to her, like, these bad behaviors need to be punished. Just because you're traumatized does not give you carte blanche to traumatize others. I know that's something we see constantly in the criminal justice system. I can't think of a single defendant we've had over there who themselves has not been the victim of trauma in the past. I think a lot of people don't know that. So that's what my hope is for this sentence. Thank you.
Thank you, Your Honor. In entering in this plea today, Ms. Mott is paying a price for her actions. She is accepting responsibility for them and is suffering the consequences. I agree with the state in that for someone who has essentially no prior criminal history, that in full honesty, looking strictly from the outside, a year of probation and a 30-day jail sentence may seem severe. I do want to clarify on the record that we are requesting eligibility for ankle monitoring. I understand that Ms. Mott has the funds available for that program. Just wanted to clarify that on the record. But I think that this is an appropriate recommendation of the Galleon factors. Ms. Mott actually was the one who proposed the 30-day jail sanction. I think jail is going to be very appropriate as a deterrent for future behavior, given the nature of this offense, and considering that she will be on probation for a year, she will be further supervised in the community. The community, Your Honor, will be protected from any further violations through this supervision by DOC. And the programming available to Ms. Mott through the department to address any potential mental health, substance use, trauma-related issues will allow her to address her needs. As I've provided in documentation to the court, she has already taken that first step and has reached out for an AODA and subsequent follow-up sessions. She is working forward on moving her life past these incidents, putting distance between herself, between the parties here at issue. She advised in the days leading to this hearing that she actually received an offer for a job out in Lake Elmo, and has considered the possibility of relocating to Minnesota entirely. Lastly, Your Honor, in reference to the letter that she had written and I had submitted to the court, I think what Ms. Mott wants to indicate very clearly to this court is that the relationships that she's had with these individuals have caused her a tremendous, tremendous amount of pain. And I think going forward, her single goal, if she were to only have one, would be to not have any pain anymore. I think that this is an appropriate recommendation, and I would ask the court to follow it. Thank you.
Thank you. Ms. Mott, I do have your written statement that you filed here today, and I have read it, and I have highlighted parts in it, and off the record or on the record, I believe Mr. Schmidt has indicated the state has received that and reviewed that as well. Would you like to make a statement here today in open court?
No, thank you.
The court is going to take judicial notice of 23 CV 85 and 23 CV 83. That would be the injunction cases with Christy Haskins and Jason Haskins versus Victoria Mott. 22 CF 46, because it is relevant and does pertain and has a connection with this case and other cases. The state of Wisconsin versus Jordan Haskins. The court is going to take judicial notice of 22 SC 208, and that would be the incident or the case involving Christy and Jason Haskins versus Victoria Mott, the small claims matter. This court has sat on all of those cases. I was the judge on all of those cases, and I have heard, for the most part, what was recited by the state in its argument. The court was not completely aware of the relationship in 2016 with Ms. Strunk and how that occurred. However, the other facts, other than any just incidents that were reported to the police, the court was aware of. And this case is something like I can put a timeline with all of the things that have occurred, even though they are different cases. If we had one case separately, this may be less serious and not aggravated, but we have all of these cases that together, in looking at it, which the court can do, and looking at the history, the totality of all of the circumstances, the court can look at that in rendering judgment and making a decision in the case. I have reviewed your statement, Ms. Mott. It is very lengthy. There is no doubt in my mind that you have been a victim. You are a victim. There was domestic violence. There could still be between you and Jordan Haskins. The court was well aware of that back in the 22 SC case, and then having the 22 CF criminal matter with Mr. Haskins. You have been a victim of domestic violence. But in reading your statement, and I'm not going to read it out loud because again, it is very lengthy, but in reading your statement, you feel like you're the only victim. Like it's that you have been the one who is seen, who has been unjust, that the system has been actually harming you and not protecting you. You at no time acknowledge and admit your actions and what you have done.
Towards the end of the letter, I did, and I apologized.
Yes, you
And-
apologize, but that's just like a child that gets into trouble, that has a tantrum, that does bad things, that the parent then goes and reprimands, and then the child continues to say, but it's your fault, it's your fault, it's your fault, it's somebody else's fault, it's everybody else's fault. Oh, but I'm sorry. Get me out of trouble. Don't punish me so bad. It's not a true apology. It's not a true apology. If you truly felt that you have wronged the Haskins, if you truly took accountability and responsibility for your actions, it wouldn't be 3-4 years later that we're still dealing with the same conduct. I've said this before and I'm going to say it again. Your relationship with Jordan is toxic. It's toxic. And I don't know if it's Jordan. I don't know if it's you. I don't know if it's the both of you. It is toxic. And you say in your letter, I'm very well versed in domestic violence. I represented domestic violence victims for many, many years free of charge. You make a statement that the system should know that victims go back to their abuser. They continue to go back to their abuser. That is very true. It takes approximately 8 to 10 times for a victim to leave their abuser before they have enough strength to continue and to move forward. I get that. But there is also this cycle of joint abuse, joint domestic abuse involving both the male and the female, or whatever the significant others are. The fact that you say that in your statement, that the system should know the victims always go back. And I went back and I'm continuing to go back and I see that he can change and I want to be there to help him change. It sounds like you're playing the system. You know domestic violence, you know the facts. You've went through the CRA class, the Community Referral Agency class. You're spewing the things that you want the court to know or to take into account. I'm aware of those things. if you're aware of those things, you should have, you know those. You reach out to your advocate, you reach out to your friends, you reach out to your family. You don't continue to go back each and every time to the place that you were ordered to stay away from. That was plain and simple. Back in the 22 SC case, the small claims case, you were told to stay away from that house. Then back in the 23 restraining order cases, you were told specifically in that order in black and white to stay away from that house. I can't, and I believe I reprimanded the Haskins as well back then. I believe I told them the words that they cannot control Jordan. If Jordan is an adult and if Jordan wants to see you, that is for Jordan to do. They can't control him. He is an adult. They cannot control you. You are an adult. However, they can control, and this court can control whether or not you ever step foot on that property and you violated it. How many times? More than these 5 or whatever times are alleged here. More than that. I believe Mr. Haskins. I believe Jason Haskins when he says you were flaunting to him that you were sleeping in the same house. I believe him. I don't believe you. I don't find you credible because this has happened over and over and over again. And I had to be harsh with Jordan Haskins in his criminal case. I've held him in prison, or not in prison. Luckily, he didn't go to prison. I put him in jail 60 days, 90 days. I kept increasing those days so he can understand the significance of having contact with you anyway, because he had no contact, but then with you at this house. And when you go to this house, it's pretty much sticking your middle finger up at the Haskins. You're saying, I don't care. I don't care what you feel. I don't care what you think. I don't care that you own the property. I don't care that you support your son. I don't care that you do anything. I don't care that you exist. I'm going to do what I want to do. Because in that small claims case, there was criminal damage, there was damage to that property. You admitted so on the record of that damage. You admitted to try and pay for it. You admitted to try and work it out with the Haskins so you could pay for it, so it would go away. They more so wanted your behavior controlled, you away from that environment. They really wanted you away from Jordan, but they used the avenue that they could with regards to those damages and the eviction. That wasn't an illegal eviction. I sat on that case. I heard everything. That was not an illegal eviction. It is not. You had your time to talk. You did not. I read your multiple
Quick claim
cases.
deed wasn't filed for over a year after that.
Please don't
Your
talk. I told you to stop talking. Not your time to talk. I have so much empathy for domestic violence victims, and I believe that you were and could potentially still be a victim with Jordan. Again, I don't know. I'm guessing that this has never stopped. It has never stopped. You are addicted to this cycle. You are addicted to Jordan. You know he's not good for you. You know he's not good for your son. You know he's not good for your life, because look at where you are. Now you're a convicted criminal. I don't know what you had prior to this, but now you are a criminal forever and always. And Miss Mott, I'm going to guess, this is coming down really harsh on you right now, but I'm going to guess prior to Jordan, you were sweet and kind, and you were not retributive. You were not trying to destroy people's lives and their property and to do those things. Again, you and Jordan are gasoline and fire. Gasoline and fire. And if this doesn't stop, something more serious will happen. Something more serious will happen. Somebody could be injured. Mr. Haskins could have been hit by that car. You could have been here for a reckless homicide, substantial battery, multiple other crimes. If something were to have happened to him, he just had back surgery. And he should not have been standing in the driveway at that time after back surgery, but he thought he needed to do what he needed to do to protect his property. And I'm harsh on you right now, and I'm going to tell you right now, I'm going to guess that at one point in time, at one different case or another, the Haskins have thought that I've been harsh on them too. I have to look at the facts in front of me for the cases. This got out of control. Every single time you went over to that house, you made a choice to go over to that house, not only knowing it was against the Haskins' desire and their wish, it was against the law. It was against the law each and every time you stepped foot on that property. But not only did you step foot on the property, you did donuts, you did other things that caused havoc to that property, and it got you nowhere. It didn't get you any good. It puts you in the light of the person who is doing all of the wrong. If you and Jordan cannot stay away from each other, if you and Jordan must be together, it cannot be on this property. You cannot step foot on this property one more time. Miss Haskins at this last one could have been injured. And I did read in yours that you said that she was holding you down or they were pulling your hair. Well, they were calling 911 or calling the police. They were trying to get a perpetrator out of their house. You're shaking your head. No, you were.
They were blocking the door so I couldn't leave.
You should never have
I know,
been there.
I understand that, Your
Not
Honor.
ever, never have stepped foot on there.
I know, I
But
get
that was your 20th time. And you're not getting it. You're just not getting it. You're risking your life. You're risking your son's life. You're risking your future, your reputation, all of these things. And I have to ask, is it worth it? Is it worth it? Is Jordan Haskins worth it? Because I don't think he is. Not for you. And hearing the recommendation, and Mr. Schmidt was saying, well, 30 days, is that going to be too harsh? No, not when we look at the factors in those things. In his argument, I'm thinking, is 30 days too harsh? Is 30 days too lenient? Because it happened over and over and over again, and it escalated. And I believe, again, Mr. Haskins, when he says he made those trips multiple times a week to try and circumvent this, to try and stop this, so you wouldn't have a clue when he was there. And I do believe his speculation that when he was sleeping in Jordan's bedroom, there was a different car there that you didn't recognize, and you thought it was another woman. And you went berserk. You went crazy. You did donuts in their yard. You could have been charged with criminal damage on multiple occasions. So I have to look at this and I have to craft a sentence because this is serious. I have to craft a sentence that looks at you now, that looks at your past behavior, that tries to look at the crystal ball for your future behavior. And I need to protect the community. That means everybody as a whole, but in particular, the Haskins and this property. And to ensure that you understand that you'll get it. You'll understand you cannot ever step foot on that property. Never. If you do, there will be ramifications. The court, in trying to figure out and get a sentence that will accomplish all of the things, I need to look at also deterrence. I need to deter you from continuing to do this. I need to deter you from doing this. This is not a general deterrence where I'm deterring others, unless if we're looking at people violating restraining orders. I need to make sure I craft a sentence that deters you from doing anything further. That if you do this again, there will be serious consequences. I cannot extend the restraining orders at this time as the Haskins has requested, as they have requested. However, I can again craft a sentence that can try and meet the objectives of the victims, as well as the justice system. So in doing so, the court is going to do 2 years of probation, because that puts this out then to 2027. That puts us out to the length of the restraining orders, or close to, a little bit over. That is the longest that this court can go for probation. And with regards to actually sentencing, I'm doing an imposed and stayed sentence. If I were to do a straight sentence, even the straight maximum possible penalty, that doesn't accomplish and won't accomplish more protection for the Haskins and having the hammer over the head to ensure that you actually understand it, that you're not going to do it again. I have 25 CM 30, which is count 6. And then I have the 2 other counts in 25 CM 125, which would be count 2 and count 3. In 25 CM 30, what the court is going to do is I'm going to do an imposed and stayed sentence of 6 months in jail. If you're revoked off of probation, you will sit 6 months in jail for that count. In 25 CM 125, count 2, I'm sentencing you to an imposed and stayed of 6 months in jail, consecutive to the other count. That means if you're revoked, you will sit a whole year in jail. That's a long time to have to think and to contemplate. For count 3, I'm sentencing you to 6 months in jail. That is concurrent to count 2, but consecutive to 25 CM 30. So again, if you're revoked off of probation, 1 full year of jail. That is a very long time. I am sentencing you to conditional jail on top of the sentence that I have already laid out. For 25 CM 30, count 6, 30 days of conditional jail. 25 CM 125, count 2, 30 days of conditional jail, consecutive to 25 CM 30. In count 3, 30 days of conditional jail, concurrent with count 2, but consecutive to 25 CM 30. 60 days of conditional jail. It hasn't been enough for this court to reprimand you. It hasn't been enough for this court to look you in the eye and tell you, stop, you cannot do this. It hasn't been enough for this court to tell you and to say, look, gasoline and fire. This is a very toxic relationship. It's a toxic relationship. It has caused not only Jordan Haskins to get into serious criminal trouble and to sit serious jail time, it has now gotten you into trouble, and you are going to sit serious jail time, which could be substantial if you violate your probation. While on probation, there will be absolutely no contact with Christy Haskins, Jason Haskins, or any of their family, including Jordan Haskins. So you'll figure that out. No contact with any of the properties, and that does include the properties listed in the injunction. 6050 Cherry Circle North in Hudson, 26996 County Road A in Spooner, 702 Walter Street in Spooner. Absolutely no contact. If you think you need to drive to the grocery store and drive by one of those properties, I'd find an alternate route. I'd go 40 miles out of your way instead of driving by that house or one of those properties. I am also ordering a mental health evaluation and follow through. I am ordering domestic abuse programming completion and follow through. Absolute sobriety. No alcohol, no illegal substances. Gainful employment. What was the longest time you sat in jail?
I don't recall, 30 days maybe. I don't know.
So you have a criminal history?
I got a misdemeanor once years ago for paraphernalia for, it was over 12 years ago, I think.
Wow, that's
Well,
serious.
no, it was literally, I got arrested and then I just sat until I was sentenced pretty much.
Okay. Well, 60 days will be no piece of cake. I'm going to give you 30 days to report to jail. So you have 30 days to get your affairs in order. I am not approving electronic monitor at this time. Consider that. But at least at this time, there needs to be punishment. House arrest, electronic monitor is punishment, but it's not the same punishment. It doesn't have the same deterring effect because then you can go about your normal life. You could have people to your place of residence. You could do fun things at your place. This is a deterrence. This is to deter you and to punish you from this continuous, ongoing, aggravated behavior. I will consider a motion for electronic monitor after 30 days. And again, why I am not considering electronic monitor is this county does not have the monitors that I would put you on. Because I want, if you are going to go on an electronic monitor, the county would need to order a different one because it would need to be one that is GPS, that is put right on your ankle, that cannot be removed. So they can see exactly where you are at all times. The court is ordering $443 in fines and fees for the count in 25 CM 30, $200 DNA surcharge for the other 2 counts in the other case. I'm waiving the other court costs and fees. I don't think a financial punishment will have the same deterrent effect as having the jail time. I'm ordering your DNA. You must go to the jail and provide your DNA. You're going to need to have minutes so they know that you are not to be put into jail today, that you have 30 days. So when we're done, you need to come and get the minutes so that you can go provide your DNA. You would have the ability to request it be expunged through a written letter to the Department of Justice, not to the court, to the Department of Justice. The ticket matter is now dismissed as well and read in. You will have monthly payments beginning in November to be paid by the 15th of each month of $50 a month to be paid towards your court costs and fees. If you fail to make your monthly payments, you could get a warrant and sit an additional 6 months in jail. I'm going to have Department of Corrections collect that since you will be on probation for the period of 2 years.
Your Honor, so what's the grand total that I will owe? If you could.
$843.
Okay, I can pay most of it today.
Well, I do appreciate that. How much can you pay today?
I'll pay $450.
$450? If you can pay $600 today, I'll waive the rest. But I can't waive any more because that's all mandatory. 600? All right, so I will only assess $200 DNA surcharge per count, total of $600 to be paid today. And I'm doing that again because the financial aspect is not the punishment. The punishment is the jail and the potential significant substantial jail if you violate. I don't know if she has, I don't believe she has jail credit for here. Mr. Schmidt, what is the court missing? If you fail to pay, not only will a civil judgment be entered against you, you could sit up to 6 months in jail. Mr. Schmidt.
Nothing from me.
Mr. Felisky.
Nothing further. Thank you.
Ms. Mott, I want you to understand what I see and what I understand. And I believe to some extent the Haskins may have an understanding of this either, or too. Jordan Haskins is not 100% innocent in this. You have been a victim of him as well. He has asked you to go to the house. He has played a part of this. But you are the one who had all of the risks. And then you escalated it with Mr. and Mrs. Haskins. They're parents and owners of a property that are trying to do right. You are an individual in love and you are blinded by that. Ms. Haskins or Ms. Mott, you need to, I say need, and you should respect yourself more This is not something that you should want to be involved in. This is not a relationship that brings you happiness. It is not a relationship that brings you stability. It has only caused destruction and devastation for both of the families. I don't have a doubt in my mind that you are a good mother. I read it in your letter that you are giving your son stability right now while you're going through instability. That's a hard choice to make. I have a good feeling that once you're able to disconnect and get away from Jordan and to get some therapy, you're going to be a different person. And I don't think the Haskins are going to have to worry about that. You have to recognize your worth. And so far, you don't believe you have any.
Your Honor, in light of Ms. Smott's advice to me regarding potential property remaining, a personal property of hers remaining at Haskins property, we are asking permission for one visit accompanied by law enforcement for her to retrieve her personal items.
I don't believe I can do that in this order without the Haskins' approval of having law enforcement and having a visit to go there. I can ask them if they would approve of one visit with law enforcement present to retrieve any belongings she may have there.
I'm just mainly concerned about my grandma's things that are still there.
Sounds like she has personal property of her grandmother's that is still there. Would she be able to retrieve that with law enforcement, Mr. Haskins?
I can't.
And you may still be present.
Yeah, that's fine.
Yes. You may do so within the next 30 days. All right, before you turn yourself into the jail. And you need to make sure that's prearranged with the law enforcement. And Mr. Feliski, I'm going to say that it needs to be prearranged with you and Mr. and Mrs. Haskins. Okay? That's okay, Mr. and Mrs. Haskins, to speak with Mr. Feliski about that? Okay. All right. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that covers everything. And we are adjourned. Thank you.
Thank you.
What happened that day and why you were charged with the crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Admitting here today, you in fact did operate a motor vehicle while under the influence.
Yes, Your Honor.
Are you stating here today that it would be either your 5th or your 6th conviction?
Yes, Your Honor.
Are you pleading guilty to this offense because you are guilty?
Yes, Your Honor.
Mr. Benson, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Ms. Patra, for you to plead guilty today?
No, Your Honor.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Has he looked at the discovery, the evidence in this case, and discussed it with you?
Yes, Your Honor.
Has he discussed with you whether or not you have any legal defenses or a lack of defenses?
Yes, Your Honor.
Has he explained to you that it is your decision on whether or not to go to trial?
Yes, Your Honor.
Is it your decision and choice to plead guilty today?
Yes, Your Honor.
Are you satisfied with his services?
Yes, Your Honor.
Mr. Benson, do you believe that there's any reason the court should not accept a plea from Ms. Patra today?
There is no reason, Your Honor.
Do you believe she is entering her plea competently
Yes,
and that she fully understands her constitutional rights and what she's giving up?
she does, Your Honor. We read it word for word.
And she fully understands what the state would have to prove her guilt beyond a reasonable doubt?
Correct. The highest burden under the law.
Thank you. All right. Do you have any questions for the court or for your attorney before I proceed?
No, Your Honor.
As to count 1, OWI 5 or 6, a class G felony, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I will find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1, Count 2 will be merged and dismissed with count 1. The TR matter will be dismissed and read in. A judgment of conviction will be entered today. Mr. Benson, before we proceed to arguments, how many people will be making a statement on Ms. Patra's behalf?
I would have to, I assume all of you would, or
Whoever will be making a statement, please come up and sit in the jury box. You will have a seat right here in the witness stand, and you will provide your statement to the court. All right, sir, you're last or you're first? So just come right up here. All right, when you are seated, you can come in here. Nope, right in here. You should be able to open a door. And then have a seat. Speak slowly into the microphone and enunciate your words, please. First, state your name and your relationship with Ms. Patra.
My name is Mark Flom. I work with Cindy at Parker. I am the manufacturing engineering manager at Parker.
Can you spell your last name?
FLOM.
All right. What would you like the court to be aware of?
First and foremost, Cindy is a highly accountable person, both at work and outside of work. She has a huge heart and does everything she can to help everyone at our Parker facility. We had 2 gentlemen on my team that had very serious medical issues within the last couple of years since this event has happened. And she was the first person to stand up and do fundraisers for those 2 individuals and raise several $1,000s for both of them. Beyond that, Cindy does a great job making sure everyone at our facility feels welcome and takes care of everyone. Sometimes she should take care of herself better than that, but she is an awesome person.
Thank you, Mr. Flom. You may go have a seat in the back. Next individual, please. Please state your name, spell your name for the record, and your relation to Ms. Patra.
My name is Dale Bistram, DALEBISTRAM, and Cindy is a part-time casual labor employee for me, and she did work for me for about 3 years before she got hired at Parker. And I just got a 1-page letter here, if I could read that I wrote, just so I know what I'm saying here is.
If you're going to read something, please read it slowly
Okay.
and enunciate your words. My court reporter does need to take everything down.
Sure. Again, my name is Dale Bistram, and as of December 1st, I will have owned the Country Cafe in Grantsburg for 10 years. Between this restaurant and other private and corporate restaurants, I have been in the business for about 34 years. Most of that time has been in management, either managing corporate restaurants or my own. In those 34 years, I hired over 500 employees, so I would like to think I'm a pretty good judge of character. I first met Cindy Patra in 2018 when she came into my cafe to apply for a job for cooking. I interviewed her for about 10 minutes before I hired her on the spot. She worked for me for about 3 years before getting hired on at Parker full-time, which I understand because Parker could offer her benefits. Since then, Cindy has worked for me as casual labor. For instance, last Sunday, I had a cook that didn't feel well, so Cindy was at my cafe within 10 minutes and finished out the day cooking. I consider myself lucky to have someone like that can come in on weekends at a moment's notice and do a great job. My customers and my employees truly enjoy her. Cindy has also been there for me outside the cafe. For instance, when I needed help right after my dad passed away, Cindy was right there to help me with cleaning up around the farm, even going as far as jumping on the hay rack, stacking bales, only taking a couple bales for herself as compensation. There are a few people that I know that would do that. In the years that I've known Cindy, I have watched her grow in her professionalism, dedication, and integrity. From myself working at Parker, I still know many people there, including management, and I've never heard a bad word about her. As for my cafe, again, people enjoy her, being able to step in wherever and do what it takes to get the job done, making sure my customers get taken care of. Finally, may I be the first one to say, Cindy is needed by me Parker, and the community. I would ask that you allow Cindy to keep staying active in the community and to be able to still contribute to all that have become to know her and appreciate her. Thank you for listening.
Thank you, Mr. Bistrom. Next. Again, please state your name, spell your name, and your relationship to Ms. Patra.
Good afternoon. My name is Anthony Wolf, Anthony Wolf, and I'm the Assembly Supervisor at Parker and a co-worker of Cindy Patra. First and foremost, thank you, Honor, for allowing us the opportunity to speak on behalf of a co-worker as well as a friend. I have worked with Cindy for roughly 6 years now, and she has helped me at vital points outside of work as well as inside of work. There have been times where I've had broken down lawnmowers, and she has graciously driven her own lawnmower to work to allow me to borrow. She is a pivotal person at work on our engagement team. Anytime that there are fundraisers or other raffles that we are putting together, Cindy is typically the person that is deciding which organization those funds and proceeds are going to. And just for me personally, 2 years ago, when my youngest was born, and my brother in Ohio passed away, and I didn't have a lot of funds. She was the first one to go around work and get enough money together for me to go to my brother's. Sorry. And I don't know that I'll ever be able to thank her enough for putting herself out in front of everybody to get that arranged. So that's just, I want everybody to know that she is the person that would take and give you the shirt off of her back in any situation, regardless of the circumstances. Thank you.
Thank you, Mr. Wolf. State your name, spell it, and your relationship with Ms. Patra.
Good afternoon. My name is Matthew Olson, Matthew-Olson. I am the plant manager at Parker in Grantsburg and have had the privilege of being a coworker with Cindy for the past 5.5 years. What's really impressed me with Cindy is how much I've been able to see her grow in those 5.5 years. She started as an assembly operator and was able to get promoted to a brand new role within our organization. And it was a very open, undefined role, but she, while didn't have the skills to originally work the role, she took it upon herself to really learn those skills, computer skills, leadership skills, as well as manufacturing principles, to the point where she was able to lead others within our organization. She's counted on not just at our location, but several locations across our corporation. She does that through an incredible can-do attitude. She is one of the people that thinks about what we can do, not what we can't do. One of the most honest individuals that I have the privilege to work with. She is always able to share with us what we need to do differently and how to do things better. She's a great advocate for our team members on the shop floor. I will echo what others have said from the engagement standpoint. The involvement that our organization has within the community is a direct result of the initiatives that Cindy drives to make our community a better place, in addition to our work environment. The other thing I would really like to emphasize is we are an organization under tremendous growth right now, and she is a leader of our safety team. It's an organization of cross-functional team members within the manufacturing facility. She leads that organization exceptionally well, with a huge emphasis on how to make sure that all of our new team members are working safely. She leads the training and develops training initiatives to make sure people are working day in and day out in a safe basis. and really make sure that we continue to grow that culture within our organization. Like I said, it's been a privilege to work with Cindy these past 5.5 years. She's a great member of our community as well as our organization. Thank you.
Olson. All right, please state your name, spell it, and your relationship with Ms. Patra.
Okay. My name is Rochelle Hendren, Hendren. I am Cindy's sister. I'm hoping, I'm going to apologize, I'm a supportive crier. I'm hoping I do more good than harm. You know, my whole life I've been with my sister, and it has been an absolute very rough time growing up with Cindy for a good part of her younger life with drugs and alcohol and stuff like that. We didn't think that Cindy would make it this far in her life because of how reckless she has lived her life. But in the last, I'd say 15 years, Cindy has improved greatly from where she was. Her kids at one point didn't want anything to do with her. You know, it has grown so much better as she's gotten older. I myself would not be a character witness for my sister if she was still on that path. I wouldn't spend my money to fly up here to be here for this if she was still that person. What she did back in December was not right, not the right thing to do. And I know in the last over a year and a half or almost 2 years now that she's been, you know, going through this process with the decision she made that day has been extremely rough and extremely hard on her. And I know that she doesn't want this to happen again. And we say lots of prayers that she can get through this. She's a very strong individual. I too am very excited to see so many people stand up for her in her community. That is not a close friend, that is say like a drinking buddy or a party buddy or anything like that. Cindy doesn't live that life anymore. And I've been up here for the last 8 days and just see a total different person than I did when she was in a bad place. And I just know that I can guarantee you won't see Cindy here again. And if you do, you won't see me here again. I'm here to support her because she's done such wonderful things in these last, 16 years. And I see that with her kids. I see that with her community. Cindy has always been extremely helpful and giving. And even when she couldn't in the most difficult times, if it was her last dollar, she'd give it to you if you needed it more than her. So I hope I'm a good character witness, but she has come such a long way. And I'm very proud of you. And Mom and Dad would be proud too. Thank you. Thank you for your time.
One question.
Of course.
Your letter says you're from Golden Valley, Minnesota. Why would you?
Yep, we moved to
apply?
Florida in December
Okay.
because it's warm there, very warm there.
Oh, you can fly from Golden Valley, but that, I guess.
Yeah. This way we have a permanent vacation down there now, so.
Sounds great. Thank you, Ms.
You can come
Hendren.
on back if you come down to Florida. Thank you, Your
Thank
Honor.
you. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. We're asking the court to do the statutory minimum on this. I'll start first with the criminal history. It's largely duplicative of what Ms. Patra's sister just described. Ms. Patra had a pretty rough and tumble time in the 90s in Minnesota. Numerous convictions for lying to the police, for thievery style offenses, for possessing drugs. All of that stopped in the 2000s. Going from 2000 and onward, you'd only see driving without a license or her OWI-3 and her refusal. The 4 prior convictions being 2 from the 90s, actual drunk drivings, and then OWI 3 was in 2002 in Minnesota, Steele County, and then 2010 was a refusal breath test, which counts as the OWI 4 conviction here in Wisconsin, meaning it's been 16 years since a countable conviction and 24 years since an actual drunk driving offense. In particular, I'll note that 2010 one did not even charge a drunk driving, so it's not like a read-in where they think it was drunk driving or could have shown drunk driving and resolved as the other. It was just a refusal. So in this case, Ms. Patraw's previous history is extremely distant. Even that 2010 refusal, which is her last criminal conviction, was 16 years ago. In Wisconsin, though, we take drunk driving very seriously once they get up in the high numbers. We count them differently than Minnesota, where in Minnesota, if they're just spaced out over a long period of time, you can avoid a felony OWI conviction forever. But in Wisconsin, we count back once you hit 2 or more all the way through your whole history. In this case, that makes a 5 in Wisconsin. That's a mandatory prison sentence. In this case, I think that's justified as well, in particular, just because the nature and circumstances of this one, someone could have really died here. It could have been Cindy Patraw herself if she just didn't have a seatbelt on, to be honest. But there are numerous other ways it could have gone wrong and that this didn't go worse than it did. So for those reasons, I'd ask the court to follow the agreement. Thank you.
All right. Mr. Benson, argument.
Thank you, Your Honor. I couldn't describe my client any better than the 5 people who came up in front of you today and said what a quality and character person she is now. A true value to the community, loved by everyone. I don't have many hearings where that many people come out in support of someone who's going to be incarcerated. To pick up on Mr. Schmidt's talk about how our state treats alcohol, I would say within the last 5 to 10 years, the legislature has really cracked down on alcohol. I think before that, it was more of a kind of a whatever thing. Wisconsin has a reputation for that, for better or for worse. Part of this sentence, though, and I think we touched on it even at the last hearing in this matter, is that section 346.65, sub 2, sub AM, sub 5, says that there is the 18-month presumptive mandatory minimum, but it can be downgraded to 1 year if the sentencing court finds both that, 1, the best interests of the community will be served, and 2, the public will not be harmed. The court may depart from the mandatory 18-month initial confinement term if it places its reasons on the record. And I'm pulling it from a case that I'm probably going to tank the name. It's State v. Shirikian. Shirikian. It's a 2023 Court of Appeals case, 2023 WI App 13, 987 Northwest 2nd, 819.
I just want to stop you right here because I just want to make sure that you're in the confines of the agreement that you've reached with your argument. Is it free to argue, or is it a recommendation by both for the mandatory minimums?
I always phrase statutory minimum, and when I say that, I assume they can make this argument.
I just wanted to make sure that that was on the record.
Yes,
I don't view it as a breach of the plea agreement.
Yeah, I didn't think you would object. So
I just wanted to make sure, Mr. Benson, so we don't go down some other road.
No, I understand. I don't want to waste the court's time, but I do want to get a lot of things on.
I want you to say all of those
Okay.
things.
Thank you, Your Honor. So, and in touching on our criminal record, obviously I'm not allowed to keep a copy of the criminal record, but Mr. Schmidt again was right. In reviewing her driving record, the last conviction is February 28th, 2011 from the 2010 case. And I went through Minnesota's version of CCAP and pulled a lot of paperwork out of there, to be honest. But the last thing you'll find there criminally is from 2010. So, and as her sister indicated, it was rough growing up. But I think 15 years ago, the light went on. Some people enter adulthood later than others. And for Cindy, it just happened to be about 15, 16 years ago, I would say. She has done the AODA. They didn't recommend any further classes or anything like that. She has an online support group all over the country where they share each other's burdens and things like that. And I think it works out really well for her. She even completed her driver's safety plan July 31st last year. So she certainly is taking this seriously. When she and I talked on the phone this morning, because I thought she was having medical issues, she said, no, people are coming today. We're going to do this today. I'm going to finish this today. And I hope when she speaks to the court, she can tell it to you like she told it to me. I said, that is perfect. That's exactly how you should address the judge. But when you're looking at this best interest of the community, first of all, does she need punishment or does she need rehabilitation? She really hasn't done anything criminally for 15 or 16 years. And again, it is a 5-6 OWI. It's serious, and Wisconsin takes that serious. And she knows she's going to be remanded into custody today, and she knows that the bare minimum would be 1 year in state prison. And it's made her very emotional, but again, she's here taking responsibility, and she's showing the court what she's done in the last 15 years that makes her a credit to the community. Is the public safety endangered? If she were to drive again, certainly that risk would be there, I think. But to my knowledge, she will never have a driver's license again. This is more of a once-off than a pattern, I would argue. Were you to give her less time, would that cheapen what the law is intended to do with 1.5 years? I don't think it is. I don't know how many people come in front of you for sentencing like this, but I bet they don't have the support that my client does. And again, it is a very serious crime. However, I think what she's done and what she can do would mitigate the 1.5 years to look more towards the 1 year. And she understands there will be extended supervision as well. This crime involved alcohol. She used to have a bad prior record, but she doesn't any longer. Would serving less than 1.5 years and serving the year allow her to return safely to society? I think 1 year would be imperative. I think that would work for her. I think these people are chomping at the bit to get her back. I don't think they said there's a job waiting for her, but I'd be willing to bet that when she gets out, she'd be working at Parker again. And since this stop back in December of 24, she's done everything she's had to do. AODA, again, the driver's safety plan. She showed up at work. She showed up for every court hearing. She's taking this seriously. And again, she knows that she's going to have to report to the jail immediately or a deputy will be coming in. So that said, Your Honor, I'm asking the court to look more towards the 1 year instead of the 1.5 years. Thank you.
Thank you, Mr. Benson. Ms. Patra, I'm now going to ask you if you wish to make a statement here today. You do not have to. It's your choice. I see that you do have something in front of you, and I'm going to assume that it's the letter that I have read. Please, if you are reading the letter, go slowly and enunciate your words. And if you are having an emotional time, because this is an emotional hearing, please stop and take a breath before you begin again. It's hard for my court reporter to be able to take down things when they're muffled, okay?
Yes, Your Honor. Have to start my name?
No.
Okay. Before I even go to the letter, I just want to apologize for being here and for being here, taking up your time. I want to apologize to my family for putting them through this. I want to apologize to all my friends and my employers for putting them through this and what it's doing. It's make things difficult, and I'm sorry. I want you to know that this is not me. I did have hard life growing up, and I was addicted to drugs for, I'm gonna say, over half my life. And my daughter's not here right now because she had to work, but my daughter's, I give her the most credit for me coming to who I am now, because I love my grandkids to death, and she basically told me, either change your life or you'll never see your grandkids again. Well, they were worth it, you know. And it's the best thing that's ever happened to me. I realized that I'm not just that person that came from the hood or frog town or whatever you want to call it. I can be more than that. Don't have to be defined by where I came from. And I thank Parker for giving me the opportunity to prove that. And I'm more than that. And for my friends and family for being here to support me, I want to say thank you. I also want to apologize about the accident. And you're right, prosecutor, you're right. I could have killed myself or somebody else, and I do understand that, and I really apologize for that. My son drove by the spot where the accident was, and he has nightmares about it, thinking I was dead. I'm sorry to put you through that, Max. I love you. And I'm sorry that's stuck in your head. I was trying to read this letter. Dear Judge Morgan and counsel, I am writing this letter to express my deepest remorse for the mistake I made. I made that brought me before you. I fully accept responsibility for my actions and the consequences that have followed. I want to sincerely apologize to the court and to everybody affected by my behavior, to the community. I understand the seriousness of what I did, and I'm truly sorry.
Ms. Patra, you can stop and take a breath. I have read your letter. I did read it very carefully when I read the other letters. If you wish to continue to state it on the record, you may do so. But I rest assured, I did read your letter.
Thank you, Your Honor.
Want to say anything else? Do you want to read it?
I can't. I just want to say I'm sorry. And I wish there was a way that I could be on a bracelet and turn myself in every weekend and go to work and make sure I take care of my family and my responsibilities.
Ms. Patra, what happened that night?
I worked 18 days in a row, and one of them I worked at the cafe during the day, and then I went to Parker at night to do something before Monday morning and get that done. And then the next day we had a bake sale. And so I stayed late for the bake sale, and I left work, and it's Christmas time, and people from out of town were in town, and they were downtown, and I said, well, you should stop by. And I was like, okay, well, stop for one. So I thought, and I don't know if you've heard a lot about the drink was a lot stronger than what it probably should have been, what I should have been, I think. But I stopped and I got there, and the people that I was there to meet, I noticed had already had too many, and I had a drink sitting in front of me, and I told them they needed to leave. And so I finished my drink, and I turned around, was talking to somebody, and I turned around and they had filled it again. So I said that was gone, and then I left. It was snowing out pretty bad. It was like the roads were slick. It was blizzard kind of conditions. And honestly, after the accident, I hit my head because my airbag didn't work. And I honestly do not remember anything from there. I tried to get video because part of me felt like the truck that I hit may have came out of the T-Dog's parking lot. You know, I don't know it for sure because I don't recall seeing it. I mean, I don't have very good eyes either. Matter of fact, they told me next time I go to get my license that I better go to the eye doctor first. But and it was an accident. I never in the world was set up to do something like that. And I would honestly tell you this thing I went to, the lady down here at Aurora.
Take a breath.
The lady at Aurora. So I see people do it all the time. They have a drink or two and then they go home, you know, and it happens like I used to have waitress in restaurants and bars and I see it and I never thought in a million years that I could have a couple drinks and be over the legal limit. I really never did. But she told me, she said, no, it's meant that way. She goes, you're meant to be over the legal limit after one drink. And I was like, what? And being naive is no excuse. And I know that. And if I could do it all again, it would never happen. You know, I just wish I could do it over.
Thank you, Ms. Patra. And you understand that your legal limit is different than other individuals' legal limit.
No, I didn't understand that either until just recently.
Yes, your legal limit is 0.02.
Yeah, I didn't know that.
It's because of the number of OWI, DWI convictions you had. And so your legal limit is 0.02. So the Aurora individual was correct. One drink puts you over the limit.
I didn't. And being naive is not an excuse. And I know it's not an excuse. But
however, you did, your blood alcohol content was 0.115.
Mhm.
So that is over the 0.08.
Right, it's still over the legal limit. I understand. I just wish I could do it over. I never in a million years. I'm the guy trying to tell the other guy that he's had too much to drink. He should probably go home. You know, I've never seen this guy. I swear to God years ago after being in jail that I would never be here again. And I can't really believe I'm here now.
Right. Ms. Patra, I do have to say that it is very commendable that I see so many people here supporting you. And I've heard so many words of genuine care and concern and respect. I don't see that a lot. I don't see it a lot with I don't see it a lot in many of my cases regardless. So it is very good to see these individuals behind you and who will continue to stay behind you. In sentencing an individual, Ms. Patra, the court has to look at a few things. I have to look at first the nature and the gravity of the offense. How serious is this matter? Then I have to look at the character of the person in front of me. And that would be your schooling, your education, the jobs that you've performed, how you are in society and what you do. I have to look at your criminal history. I also then have to look at the need to protect the public. All right. Yes. And I have to look at if you are a threat to the public. And then I put it all together and I weigh it all out to determine what a sentence is. What a sentence is for you is different than a sentence for a different defendant, because the court has to look at all of those specific things. This is a case where the court cannot look at probation first, because this is a mandatory minimum prison sentence. The court is told by the legislature in our laws the mandatory minimum, with that caveat that Mr. Benson did go through with the case law. This is a very serious matter. Even if the court doesn't look at the 0.02 level, the blood alcohol level, It's still a 0.115. That's still almost double the legal limit in Wisconsin for a person who is not under the 0.02 requirement. So that makes it serious. The second part that makes it serious is the fact that there was an accident. You are so lucky to be alive here today.
Yes, Your Honor.
Mr. Schmidt hit it right on the head when he said that someone could have died or been seriously injured from this accident. But for the grace of God, you are here and no one was hurt. You were hurt, but you were able to recover to the best of your ability. I'm really glad to hear the statement from Mr. Benson in which he said he thought you were going through medical issues right now or needed something medically, but you told him, no, I want to move forward today. I want to accept the responsibility. I want to be accountable. I don't want to delay. That takes a lot of courage, Ms. Patra. It's not easy to sit in your seat knowing that prison is your next door. I can't even imagine what that feels like. But I am seeing a person who made a mistake. Well, you made a mistake, but you want to change yourself and to change that type of conduct so you never do it again. From hearing your statement, Ms. Patra, it sounds like not only are you a giving person, and that's the statement from everybody, you are a giving person, but you are an over-giving person. You give to everyone else and you empty your cup. You need to have time to have self-care, to replenish yourself so that you can be the best for all the people you serve. I'm not going to say I have not been in your shoes in having the weight of the world on my shoulders and having a drink or two. You have to make a different choice and not get behind the wheel. Unfortunately, you were not aware of the 0.02 blood alcohol content. However, you are aware now. And in Wisconsin, an OWI fourth offense is a felony, and that makes it a lifetime restriction on your ability to drive. The Department of Motor Vehicles will determine that. You're going to hear me say that you're revoked for a period of time and you have an ignition interlock device. I'm still required to say those things on the record. It's the Department of Motor Vehicles who will be in charge of whether or not your license is revoked for life. Okay?
Yes, Your Honor.
In protecting the public, I look at you and I look at a person who is very giving and out there for the public, for the community, but for this one time, but for this action, this day where you were overworked, you were tired, you were exhausted, and you wanted to let loose or relax. You weren't at the bar pounding them one at a time, one after another after another. You had a few drinks. I'm going to guess that they were hard alcohol by the way you've spoken about the drinks. And it hits harder. I have so many people here that are supporting you today. And I'm going to guess that if given the opportunity or the necessity, I would have a courtroom full times 10. Because it sounds like you're not only generous to each of the individuals within this courtroom, well, behind those walls in the gallery, but you are giving to a whole lot more people who would sit there and give more positive statements. I'm going to tell you, I bet I could have had 50 or 60 written statements or individuals wanting to make positive remarks about you. That goes a long way, Ms. Patroff. I'm sure you've heard, and others in this courtroom observing, I'm a judge that ensures that there is the punishment that's necessary, but I can look at the whole picture. I know I can be harsh, Ms. Patroff. Rest assured, it is not easy sitting in this seat knowing that I am sending somebody to prison and for how long. Even sending an individual who has done bad things is difficult to do sometimes. I have thought about this from hearing from the members of the community and from hearing the argument from the state and from the plea from your attorney. And honestly, I'm glad your attorney went down that road because that was already going down in my thoughts. Ms. Patra, here's what I'm going to do. I don't do this often. It is rare for me to go down this path. It is rare for me not to follow the law to the best of my ability as I understand it. The legislature has mandatory minimums. It's kind of a battle for me to not follow mandatory minimums. I think I've only done this once, maybe twice. Ms. Patra, I'm going to sentence you to 1 year in prison with 3 years of extended supervision. I am not following the mandatory minimum of 1.5 years of initial incarceration. And here's why, because I have to state that all on the record. On top of everything that I have done here today, I find that it would be in the best interest of the community, and the community would be best served with you out in the community, doing the good things and continuing that. I do not believe that the public would be harmed or that I am spitting on the law by not following the mandatory minimum. I believe that in fact, the public could benefit once you come back into the community. But here is what I am requiring because of this sentence. I am requiring that once you are released from custody, you will be in my treatment court.
Your Honor.
And that is why, that is the tip that has tipped it over for me to do a lesser sentence than the mandatory minimum. The treatment court is a lot of work. You have a lot to do, a lot of requirements. You're one step ahead because I'm going to guess you have a place to live, and I'm going to guess you're going to have a job coming back. But you're going to need time to come to treatment court, to do meetings, and to do other things. And you know what? I believe that you could benefit from that. I also believe my treatment court can benefit from you. So again, that's where you're going to be giving back to the community.
Your Honor.
You will be a positive influence for the individuals that I have in my court. And I want to tell you how rare this is for me to do this. I am assessing $3,464 in fines and fees, plus a $10 blood draw fee. There's $750 in restitution. Is that stipulated to, Mr. Benson?
Yes, Your Honor.
Plus $750 in restitution. I believe I said 3 years of extended supervision, 3 years revocation of your driver's license, 3 years of ignition interlock device. I do have to continue to order that you do the OWI AODA assessment and follow through. The statute still requires me to say those things. Now, while you were on extended supervision, while you're incarcerated.
This courtroom hearing centers on a violent assault that left a man with devastating injuries and led the court to authorize serious criminal charges against the defendant. According to testimony presented in court, the incident began after an argument involving several people. Witnesses described Mr. Higgins arriving at the location and becoming involved in a confrontation. Jordan Damron eventually came outside, and witnesses later reported that Higgins had a handgun with him. One witness said Higgins was waving the gun around before the situation suddenly escalated. When officers arrived, they found Jordan Damron lying on the ground, bleeding from his mouth and struggling with severe injuries. Witness testimony described a swollen face, injuries to his head and ear, and significant trauma that required immediate medical attention. Damron reportedly identified Higgins as the person who assaulted him and indicated that a handgun was involved. The evidence became even more disturbing as investigators learned the extent of Damron's injuries. Doctors reportedly found a brain hemorrhage and 2 fractures in his jaw. His jaw was so badly damaged that it had to be wired shut, and medical professionals believed the injuries were consistent with blunt force trauma, potentially caused by a firearm. Another witness reportedly heard Higgins deny using a baseball bat, instead saying that he had struck Damron with his gun. After hearing the sworn testimony and reviewing the allegations, the judge decided there was enough evidence to move forward. The court found probable cause to believe that the crimes of assault with intent to do great bodily harm less than murder and felony firearm had been committed by the defendant. A complaint and warrant were authorized, officially pushing the case into the criminal justice system. What began as an argument allegedly ended with a victim suffering life-altering injuries, and now the defendant faces the serious consequences of the evidence presented in court.